discussing very important topic on Section 8 company and penalties for non-compliance and fraud under Companies Act 2013. If you are thinking of registering a Section 8 company for charitable purposes, before you do, here is something critical you should know. Defaults in compliance can attract heavy penalties, and if fraud is involved, it could lead to jail under Section 447. So in this video, we will break down what Section 8 of Companies Act 2013 and what it says about defaults and fraud in charitable companies. Stay till the end. It could save it could save the company from serious legal trouble. Section 8 of the Companies Act 2013 governs formation of companies with charitable objects such as promotion of commerce, promotion of art, science, sports, education, research, social welfare, religion, environment, etc. After this presentation, I will take you to the MCA portal and I will explain about this section in detail. So profits, if any, must be applied towards the promotion of these objectives, and no dividend is to be paid to the members. So if any profit is arised out of the objects, so that also shall be used for the promotion of the objectives only. And there is no dividend to be paid to the members of the Section 8 company. So however, if the company fails to comply with the provisions of Section 8, what law says? The penalty of the company, a fine not less than 10 lakh rupees, which may extend to 1 crore rupees. Fine not less than 10 lakh, which may extend to 1 crore. And penalty for directors and officers in default, a fine of not less than 25,000, which may extend to 25 lakh. So 25,000 to 25 lakh. So this is what the penalty to the company and to the directors. The penalties apply without prejudice to other actions the authorities may take. Here is the crucial part. When it is proved that the affairs of the company were conducted fraudulently, every officer in default shall be liable for action under Section 447. So what is that 447? It deals with the punishment for fraud. If found guilty, a person can face the imprisonment for up to 10 years and hefty fines. So including a fine that is at least the amount involved in the fraud and can go up to 3 times of that amount that fraud involved. This is what Section 447 says. After my presentation, I will take you to the MCA website and Section 447. So it is not just about missing compliance for Section 8 companies. Fraudulent conduct in Section 8 company can lead to severe criminal liability. Section 8 companies are built on trust and purpose. So, but with that comes responsibility. So, ensure full compliance and absolute transparency in operations. A mistake could mean lakhs in penalties or even prosecution under Section 447 of Companies Act 2013. So if you like this video, if you learn something new, please do subscribe for more professional insights on the company law, NGO governance, and corporate compliance. Stay informed, stay compliant. So now I will take you to official website of MCA. We have 2 channels. One is RR Corporates, another one is RR Legal Talks. Please do subscribe for these channels so that you will not miss any latest updates. So I will stop here and take you to the section. Now we will go to Google. Here, mca.gov.in. Then this is Ministry of Corporate Affairs website. Here Act. Then see Companies Act 2013. Then come to Section 8. So we are discussing about Section 8. What Section 8 says? Renewal of incorporation. Section 8. Formation of the company with charitable objects. This is the heading of the section. So where it is proved to the satisfaction of the central government that a person or an association of persons proposed to be registered under this act as a limited company has in its objects of the promotion of commerce or promotion of art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other object. So broader interpretation intends to apply its profits, if any, or other income in promoting its objects, and intends to prohibit the payment of any dividend to its members. Then the central government may, by license, issue in such manner as may be prescribed, and on such conditions as may deem fit, allow that person or the association of person to be registered as a limited company under Section 8, without the addition to its name the word limited, or as the case may be the words private limited, and thereupon the registrar shall, on application in the prescribed form, register such person or association of persons as a company under this section. So what it says is Section 8 company objects we have discussed, and there is no dividend to the members, that also we have discussed. Any profits arising out of the objects also again has to be used for the objects of the company only, that also we have discussed. So on making an application by person or association of persons, so central government will register this company under Section 8, but you cannot find as a private limited or limited at the end of the company name, because it is Section 8 company. And subsection 2 of Section 8 says that the company registered under this section shall enjoy all the privileges and be subject to all the obligations of the limited companies, because it is a limited company only. A firm may be member of the company registered under this section. Firm can be a member of the Section 8 company. And subsection 4 says that a company registered under this section shall not alter provisions of memorandum or articles except with the previous approval of the central government. We have to take RD approval. So a company registered under this section may convert into itself into a company, Section 8 to company of any other kind, only after complying with the conditions as may be prescribed. So where it is proved to the satisfaction of the central government that a limited company registered under this act or under any previous company law, because now we are at Companies Act 2013. Earlier it was 1956 Act. Supposed to be registered under charitable purpose, any previous law has been found with any of the objects specified, which we have discussed, and with the restrictions and prohibitions as maintained respectively, just now we have discussed. So it may, if the company registered under old act, now it may by license allow the company to be registered under this section, subject to conditions as the central government. Subject condition means we have to go to the rules, follow the rules. So this is what, so that provision also is there. Then another subsection under Section 8, the central government may by order revoke the license granted by a company registered under this section if the company contravenes any of the requirement of this section or any of the conditions subject to which license is issued. If any contravention is there, the affairs of the company are conducted fraudulently or in any manner violate the objects of the company or prejudicial to the public interest, and without prejudice to any other action against the company under this act, direct the company to convert its status and change its name and to add the word limited or the words private limited, as the case may be, to its names thereupon registers without prejudice to any action that may be taken under subsection 7 on an application in the prescribed form. Register the company accordingly. What it says is, suppose if any contravention is there or any of the fraudulent activity or any violation, then the status will be changed and ROC will take action. So there is application for even conversion, provided that no such order shall be made by ROC unless any opportunity is given, reasonable opportunity will be given to the company. ROC will hear, then only ROC will take action. So if any order has come from ROC, that shall be provided that for every such order shall be given to the register, then anyway it has to be filed through INC 28 through the required form. Next, subsection 7 of section 8 says, where the license is revoked, the central government may by order, if it is satisfied that it is essential in the public interest, direct the company be wound up under this act or amalgamated with any other company registered in this act. This is the power of the central government. So if the license is revoked, like section 7(8) is revoked, so if the assets are there, then the central government may take action for either wound up or to amalgamate with the other company, because the interest of the public, it will advise for, it will direct for amalgamation if the assets are there, provided that no such order shall be made unless the company is given a reasonable opportunity of the being heard. So first it will intimate to the company, ROC will hear, then only action will be taken. Now section 8 of subsection 8, where a license is revoked, under subsection 8, which we discussed, where the central government is satisfied that it is essential in the public interest of the company registered under this section, should be amalgamated with another company and having a similar objects and registered under this section, then notwithstanding anything to the contrary contained in this act, central government by order may by order provide such amalgamation to form a single company with such constitution, properties, powers, rights, interest, authorities, privileges, liabilities, duties, obligations as may be specified in the order. If on the winding up or dissolution of a company registered under this section, there remains, after satisfaction of its duty, debts and liabilities, if any assets are there, they may be transferred to any other company registered under section 8 having a similar object, subject to such conditions as the tribunal may impose, or may be sold. Any proceeds thereof will be credited to insolvency and bankruptcy fund formed under section 224 of the IBC, Insolvency and Bankruptcy Code. Tribunal के Honorable NCLT may direct. Subsection 10 of section 8 says, a company registered under this section shall amalgamate only with another company registered under this section and having similar objects. Section 8 will be amalgamated with section 8 only. If a company makes any default in complying with any of the requirements laid down in this section, so the company shall, without prejudice to any other action under the provisions of this section, so this is for the default, company will be punishable with a fine which shall not be less than 10 lakh rupee, but which may extend to 1 crore rupees. Very huge penalty. This is to the company. And the directors and every officer of the company who is in default shall be punishable with a fine which shall not be less than 25,000 rupees, but which may extend to 25 lakh rupees. So this is a very, very important subsection of section 8. This is subsection 11 of section 8, talking about the default and the penalties. This is what the in detail discussion on the section 8. We also discussed about it may attract section 447, provided that when it is proved that the affairs of the company were conducted fraudulently, if fraud is involved, then every officer in default shall be liable for action under 447. 447 is again, so I'll explain what is that 447. This is what we'll go to the 447. This is punishment for fraud. Punishment for fraud. Chapter 29, miscellaneous. 447 is punishment for fraud. Without prejudice to any liability, including repayment of any debt under this act or any other law for the time being in force, any person who is found to be guilty of the fraud involving an amount at least 10 lakh rupee or 1% of the turnover of the company, whichever is lower, shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable for fine, which shall not be less than the amount involved in fraud, but which may extend to 3 times the amount involved in fraud. So this is a very serious. If any of the officer is involved in fraud, imprisonment is there and penalties, fine is there. Provided that where the fraud in question involves public interest also, the term of imprisonment shall not be less than 3 years, minimum 3 years. Provided further that where the fraud involves an amount less than 10 lakh rupees or less than 1% of the turnover of the company, whichever is lower, and does not involve any public interest, then any person guilty of such fraud shall be punishable with imprisonment for a time which may extend to 5 years, or with which may extend to 5 years imprisonment, or here it is mentioned, or which may fine extended to, which may fine may extended to 50 lakh, or with both imprisonment or fine, or with both. First one is no harm. So promoters or every officers has to be very cautious dealing with the Section 8 company. So what is fraud? This is also explained in the Section 447. Fraud in relation to the affairs of the company or any body corporate includes any act or omission, concealment of any fact, or abuse the position committed by any person or any other person with the connivance in any manner which intend to deceive, to gain undue advantage from, or to injure the interest of the company or its shareholders or its creditors or any other person, whether or not there is any wrongful gain or wrongful loss. Very widely given. This is the definition of fraud under 447. What is wrongful gain and wrongful loss? Wrongful gain means gain by unlawful means of the property to which the person gaining is not legally entitled, but gaining is wrongful gain. Wrongful loss means the loss by unlawful means of the property to which the person losing is legally entitled to. This is what about the fraud, wrongful gain, wrongful loss. Hope we are clear about section 447, punishment for fraud, wherever any officer is involved in fraud. This is what total about the section 8 company and defaulting section 8 company and compliances and involving fraud. Hope you are clear. So I will stop here, and for all updates, I request you to subscribe our channels, RR Corporates and other channel, RR Legal Talks, for not missing the latest updates. Thank you.